UC Santa Barbara in 2006, and then I went on to law school at UC Davis, graduating with my law degree in 2009. And I've been in practice about 16 years since then as a patent attorney. I work at Squire Patton Boggs, where I'm a partner in the Palo Alto office. Squire Patton Boggs is a global law firm. We have over 1,500 attorneys across the globe, over 40 offices in 22 countries spread across 4 continents. Our distinguishing feature is our global footprint, and that is particularly important for intellectual property because intellectual property is a global practice. So we like to say there's probably not a place in the world where you're doing business that we don't have an office. The agenda for today is really to answer 4 questions. The first question is, what IP tools are valuable to you? To answer that question, we'll also have to discuss what a patent is and what a trade secret is. And in conjunction with that, what does each protect, for what cost, and how are they used? And in light of that, hopefully we'll be able to make some conclusions about what box of tools or what mixture of patents and trade secrets is right for your business, which very much depends on how you're monetizing various aspects of the battery supply chain or battery itself, be that materials, manufacturing, processes, methods, or the software that runs all of that. At a high level, value is proportional to the utility cost ratio. The more useful a tool is to you, the more valuable it's going to be. And certainly the cost plays a part in its value. So the lower the acquisition costs, similarly, the higher the value that tool will be. And I often like to say that intellectual property is a tool to advance your business interests. So it is really important that you be strategic with how you invest in your intellectual property tools. If you need to pound a nail into wood, a screwdriver is not going to be a valuable tool for you. But if you have to do that job and you have purchased a hammer, well, that hammer will be very valuable to you. So hopefully at the end of today's presentation, you'll have an understanding of the utility and the costs associated with patents and trade secrets and see how they can be helpful for your business. You know, one thing that causes me the most disappointment is that as a patent attorney, I often hear clients or potential clients say that, you know, I worked with another attorney and I feel like I wasted a lot of money on my intellectual property. And I think that often comes down to whether or not you were strategic with your intellectual property. You know, if you spend a lot of money buying a toolbox full of all sorts of tools, but you end up only using 1 or 2, well, then your total acquisition costs are going to seem like an over expenditure. Intellectual property comes in 4 flavors. There are patents, copyrights, trademarks, and trade secrets. And to understand each one of these types of intellectual property, you need to ask yourself what subject matter is protected, over what geography is that subject matter protected, and for how long is that subject matter protected. So for patents, patents give you a monopoly to inventions that could be materials, they could be machines, they could be systems, they could be processes. But that monopoly is limited in time, usually 20 years from filing. And that monopoly is also limited to the geography of the jurisdiction of the granting government. So a US patent means nothing in Mexico. A Chinese patent means nothing in Canada. If you want patent protection in China, you need a Chinese patent. And if you want patent protection in the US, you need a US patent. Trade secrets, on the other hand, protect information that has economic value and that is subject to secrecy measures. Trade secrets have a potentially indefinite time period. There are some famous trade secrets like the formula for Coca-Cola or the formula for WD-40. Both of those formulations have been kept trade secreted for over 100 years. And the jurisdiction of trade secrets can be very expansive. You can get trade secret protection across the globe. I'm not going to discuss copyrights and trademarks too much. They're not that important for the battery field. Now, if you are in the software business, copyrights do play a very important role. You can get copyrights for your software code. That is considered an authored work. And copyrights do protect the reproduction, distribution, performance, and display of a copyrighted work. but that will not be what we talk about today. But I will spend about the next 10, 15 minutes describing what patents and trade secrets are and the various rights associated with them, so that we can then transition in the second half of this talk to how do you actually use these patents and trade secrets, and are those uses valuable for your business? So please stick with me for the next 10, 15 minutes while we do a little bit of background education. It probably doesn't need to be said to this audience. If you're logging in, you probably understand the importance of patents and trade secrets, but just to put a pin on it, patents and trade secrets are important to your company. They are one of the ways that investors value your company. They are an asset like any other asset you might have, and you can monetize those assets. As the second word implies, intellectual property is a property asset. It is just like physical property, like a car in your garage or a computer or a desk. These are assets that you can license, you can sell, you can make money off them. Intellectual property is becoming ever more important, especially in our modern day of employee mobility. It is not common anymore for people to stay at companies for 20 or 30 years. In fact, it's far more common for people to join your company, stick with you for 2 to 4 or 5 years maybe, and then move on to another company. Recent reports have suggested that that's one of the best ways that employees increase their compensation is by migrating between companies. And so if you have someone come to your company and learn all about your business, hopefully contribute some value to your business, but then move on to another company and even maybe to your competitor, how do you protect those contributions from that employee? Well, the way you protect those contributions is with intellectual property. And patents and trade secrets are kind of like two sides of the same coin. They offer multi-layer protection. It's sort of like a belt and suspenders approach to keeping your pants up. Patents and trade secrets offer different sets of rights, but by having both, you have a lot of options when it comes to licensing, selling, enforcing rights, depending on the various business situations that are going to come to play, which sometimes are predictable and sometimes are not predictable. Generally, I don't want to get too deep in the woods of costs, but generally patents are more expensive to acquire than trade secrets. Trade secrets are relatively easy to create. They really just entail having the right policies and procedures in place at your company, doing diligence and keeping your records and making those records securely stored. Patents, on the other hand, have a lot of formalities. You've got to hire someone to write a patent application that has to be submitted to various governments. Governments charge a lot of fees. I will say, though, that, so often clients come to me and ask me, how much does it cost to file a patent? And to me, that's similar to asking someone like, how much does it cost to give birth? I certainly could tell you how much it costs to go to the hospital and give birth to a baby, but that's not really the right question you should be asking yourself if you're thinking about being a parent. The costs associated with a baby are really the cost of feeding and clothing and sheltering that child over 18 years and maybe sending that person off to college someday. So patents are actually really expensive because of their life costs. And in fact, the filing costs of a patent or even preparing a patent are usually some of the smallest costs that you'll actually you'll incur. The costs associated with examining a patent, maintaining a patent, post-grant fees, and certainly if you ever want to enforce or license those those costs will far outweigh the initial cost to file. So it behooves you to be very diligent when you file so that you have a patent that is worth the life cost that it will incur. So let's quickly talk about what a patent is. A patent is a government-issued right to exclude others from practicing a claimed invention. And that sentence has a lot in it. So patents are government-issued rights. They are only good within the government jurisdiction. So again, U.S. patents are valid in the U.S. and the U.S. territories, but they mean nothing outside the U.S. Patents are limited to 20 years from their filing unless there's some sort of examination delays, in which case you can get extensions on that 20-year term. But patents give you the right, and this is probably the most important thing for thinking about use cases, to exclude others from making, using, selling, offering to sell, or importing your invention. So a patent is the right to exclude someone or stop someone from doing what your invention is unless they license it or they don't infringe it. But a patent is not the affirmative right to do anything. In fact, you may not even have the right to practice a patent that you have. I give you lots of examples. You could have a patent to a pharmaceutical, but unless the FDA gives you the right to market that pharmaceutical, you can't sell that pharmaceutical. You might have a patent to a lottery gambling device, but if the state in which you're working doesn't permit gambling by law, then you don't have a right to practice your invention. And oftentimes, more commonly, you might have a patent to an invention, but somebody else might have a dominating patent. Somebody else might have a patent that they filed first and maybe has scope that is broader or at least overlaps what your invention is. So again, just because you have a patent doesn't mean you have the right to do anything other than exclude people from making, using, selling, offering for sale, or importing your invention. Now, patents are very powerful because of that exclusive right. You can make a lot of money by stopping someone from doing something, or asking them to pay you money if they are infringing your patent. But patents protect a very narrow category of subject matter. At a very basic level, there are 6 things that you got to do to get a patent. You've got to have the right subject matter. It's got to be useful. It's got to be novel or new, meaning that what your invention is can't have been previously published in a single publication. That newness also has to be non-obvious, meaning that whatever is new about your invention has to matter. So if you just paint a car a color that car has never been painted, you're probably not going to get an invention for that because you're not changing the underlying function of that car. You're not making the car drive faster or drive better. So you've got to be non-obvious. You also have to have a patent application that's adequately disclosing your invention. It's got to meet the enablement requirement, which means you have to teach people how to make and use your invention. You've got to have written description showing that you possess the invention, and you've got to describe the boundaries of your invention in the claims with clarity and definiteness and particularity. And so for any one of these 6 reasons, people often file patent applications but don't get actual patents granted. So patents cover a very narrow category of information. Now, if you do have patents, they are very powerful, but they do require that you come up with, you overcome all of these hurdles. Like I said before, patents don't give you the affirmative right to do anything. If another party has overlapping patent rights, those patents could block you from practicing your patent. So just because you have a patent doesn't mean you have the right to even practice your own invention. It may be the case that you've got to license patents from somebody else, even to practice your own invention. Okay, let's talk about what a trade secret is. A trade secret is any secret information that has independent economic value from not being generally known or reasonably ascertainable by proper means, and is the subject of reasonable efforts to keep it secret. So let me harp on that sentence for a little bit. There are 3 main requirements for a trade secret. First of all, it's got to be information. And secondly, that information has to be economically valuable because it's not generally known or reasonably ascertainable by proper means. So there's got to be some kind of economic prong or valuation to that information. And furthermore, in the third requirement is that that information has to be subject to secrecy measures that are reasonable under the circumstances. So even if you have information at your company that you think is economically valuable, if you're not taking the right steps to maintain its secrecy, then you may not have a trade secret, even if you think you have a trade secret. So trade secrets are really easy to create as long as you have the right policies and procedures in place, as long as you're diligent in your record keeping, as long as you have the right secrecy measures instituted to maintain those secrets. On the other hand, trade secrets are very easy to lose. Once a trade secret is publicly known, it is gone. So once that cat is out of the bag, you cannot put that trade secret back into the bag. And I'll mention it now and I'll reiterate it later, but trade secrets are information that you can communicate to someone with a non-disclosure agreement, and that's how you should communicate that information if you have a business reason to do so. However, if somebody breaches their non-disclosure agreement and ends up publishing your trade secrets, just be aware that, while you might have a cause of action for breach of the non-disclosure agreement, you still will have lost your trade secrets if that person publishes your trade secrets. So trade secrets are easy to lose. Now, one of the benefits is they don't have any time limit. So we'll talk about in the licensing context, And I'll mention this now and I'll reiterate it later. When you license a patent, your royalties are limited to the patent term of your patent. So if you license a patent and it expires, you can't acquire royalties for that license beyond the term of your patent. In the battery field, that is particularly relevant because of the long lead time it takes to get to market. It's not uncommon for people to file patents and take 10, 15 years to perfect their product before they go to market. And by the time they go to market, they may only have 10 or 15 years of patent term left on their patents. And if that's the case, then your license revenue is also going to be limited by those patent terms. Trade secrets, on the other hand, don't have any time limits as long as those trade secrets are kept as secrets. So if you license a trade secret, your royalties can extend far into the future beyond when a patent license could. Now, trade secrets protect the right against misappropriation. So trade secrets are different than patents. Remember, patents are the right to exclude someone from doing something. Trade secrets really prevent the unauthorized acquisition, use, or disclosure of another person's trade secrets. So what does that mean? That means that if I have a trade secret, I can limit how you can use that information. I can have a confidentiality agreement with you. I can have a non-use agreement with you, which says that I can tell you a secret, but you can't do everything that you want with that secret. Similarly, if you hack into my computer and you steal my trade secrets, that is also an unauthorized acquisition or use of my information, and there are penalties associated with that. There can be civil penalties associated with that. And interestingly, for trade secrets, there's also criminal liability associated with the misappropriation of a trade secret. If anyone's heard of the Uber Waymo litigation or similar litigation, trade secret theft is akin to someone coming into my house and stealing my wallet or stealing my car. Now, you will never go to jail for infringing a patent. The worst that will happen if you infringe a patent is that you might have to pay a hefty fee, or you might be enjoined, being stopped from doing what you're doing. But that's the worst case scenario with patent infringement. On the other hand, with trade secret misappropriation, in addition to civil penalties, meaning you might be enjoined from stopping use that trade secret, or you might have to pay a hefty penalty for misusing that trade secret. If you steal a trade secret, you can also go to jail for criminal liability. How are trade secrets lost? Typically, they're lost in very common ways. Rogue employees is what often gets out into the news. An employee is disgruntled. They want to go to their competitor right before they leave your business. They tend to download a bunch of files on a thumb drive or their email and take that information off to one of their competitors. So rogue employees is often one of the ways that trade secrets are lost. Security lapses. If you don't maintain the secrecy of your documents, you can lose your trade secrets. So I have a lot of people that send me information on Google Drive, and I often caution them, make sure that Google Drive is password protected. Make sure you have two-step authentication to get in, because if someday you try to enforce your trade secrets and through discovery, people find out that, you were sending Google document links to everybody that weren't protected, then that information is not a trade secret. Similarly, too, even within a company, you need to have the right security protocols. So segregation is a really important thing to do within a company. If you have trade secrets, it's probably not the place of your receptionist or your janitor to have access to those trade secrets. So if you have an open cloud and everyone can access everything, you're probably not protecting anything. People should know trade secrets on a need to know basis. If they have a need to know that trade secret to get their business done, then they should have access to that. But if they don't have a need to know that trade secret to get their business done, then they shouldn't have access to that trade secret. And then non-confidential disclosures. So very often when you partner with other businesses, you sign non-disclosure agreements, you have to share information. And if people breach their non-disclosure agreements, or if you don't have a non-disclosure agreement in the first place, those are other ways that people can lose their trade secrets. Now, I said, I've been practicing for about 16 years now. And when I started, the apparent value of patents was widely known. People had heard about multi-million dollar, multi-billion dollar patent judgments that you hear about in the courts. And so people often thought, patents were kind of like buying a lottery ticket that had a pretty good chance of winning. trade secrets are becoming ever more important today than I've ever seen in my practice to date. Just as one example, last year, Walmart was found liable for $220 million in trade secret misappropriation. Walmart had entered into licensing negotiations with a company called Zest Labs, and Zest Labs was developing a certain type of source code they were offering to Walmart. Walmart passed on licensing that source code and then went and developed a competing platform. And through litigation discovery, it was shown that there was quite a lot of similarities between the source code that Walmart developed and what was being offered to them by Zest Labs. Now, because Zest Labs had taken the right steps to protect their trade secrets, they had the right records, they had the right secrecy measures, they had the right policies in place, they trained their employees the right way. Zest Labs was successful in litigating Walmart, which, oftentimes clients say, what's the point in doing all this work if some big company like 3M or BASF or CATL, I mean, they've got all the resources in the world. How am I ever going to go up against a giant like that? Well, here's an example where somebody did defeat Goliath, and for $220 million. So that's certainly a judgment I don't think you want to find yourself on the wrong side of. And it just emphasizes the importance of trade secrets today in a way that I've never really seen before in my practice. I do want to make this point that, there is a difference between confidential information and trade secrets. Trade secrets really are different from confidential information in the economic value prong and also the reasonable efforts to maintain their secrecy. So, there might be one of your officers of your board or your CEO that has a terminal illness. That certainly might be information that you don't want to get out into the public because you just don't want people to know that you might have a change in leadership. But whether that has independent economic value and whether you're taking secrecy measures internally to maintain that information may mean that is not a trade secret, is rather just confidential information. Typical trade secrets are customer lists, manufacturing processes, chemical compositions, software development, and also invention disclosures. So inventions that you're thinking about filing as a patent are a trade secret until those ideas are public. And in the same vein, if you have filed a patent application, but that patent application hasn't yet published, that patent application is also a trade secret up until its publication. So just summarizing quickly about trade secrets before we go on to use cases. Indefinite duration, cheap and easy to make, broad range of information protected. You can get injunctive relief, meaning you can enjoin people from stopping to do certain things. And I'm just going to go forward a little bit. Some of the advantages that trade secrets have over patents is that they do protect broader subject matter. They don't have those requirements. You don't have to file documents with the government until you actually litigate them, and they have longer terms. Now, some disadvantages of trade secrets over patents are the fact that you do have to create the right secrecy measures within your company. They are vulnerable to threats, both external and internal. Trade secrets also don't protect things that can be reverse engineered. So if you're developing a new battery and your trade secret is the thickness of your separator or the mass loading of your cathode or the particular metal alloy that you're using for a current collector, you may think that's a trade secret. But if you're selling your battery on the open market and someone can buy that battery and disassemble it and find out all those things that I just mentioned, if they reverse engineer it and they discover it, they haven't misappropriated your trade secret. They've actually used lawful means to find out that information, and they cannot be liable for trade secret misappropriation. The biggest one is also that in addition to reverse engineering, trade secrets don't protect independent inventions. So if somebody can independently come up with the same thing that you consider a trade secret, you might have a trade secret even if they also come up with the same idea, but you have no enforcement against that person. Whereas with a patent, if somebody independently comes up with the same invention that you patented, you can exclude them. So that's actually one of the main reasons you do find a patent, is that someone might copy you either directly by buying your product and coming and copying what they've bought, or they might just arrive at the same ideas that you did through diligent research and innovation, and thereby copy you. So patents protect anyone that independently comes up with your ideas. Trade secrets do not. So this just summarizes that trade secrets don't protect reverse engineering, independent invention, or lawful conduct. So if you are talking about your ideas at a conference and somebody records them, they lawfully acquired your trade secrets and you can't do anything about that. Okay, before we get into some of the use cases, I just want to say that there is a Venn diagram of utility for patents, and there is overlapping portions and non-overlapping portions. So remember, with a patent, you can exclude anyone. It doesn't matter whether they were privy to your communications or they didn't even know that you existed. You can exclude them from practicing your invention 20 years from the time that you filed and in the jurisdiction in which you filed. Trade secrets, on the other hand, are really only useful against confidence and criminals. So, confidence being people with which you have a confidential agreement. Those are your employees, those are your partners, those are people that you're having licensing negotiations with. So, with all those types of people, if you have some kind of confidential relationship with them and you share that information under that confidential relationship and they misappropriate your trade secrets, you do have a right to enforce against them. As long as you keep your trade secrets secret, their term is indefinite, and the jurisdiction is not limited to a government because a government is not granting you those trade secret rights like a patent. Every country has different trade secret laws, but most first world countries do have trade secret rules. Now, where patents and trade secrets overlap is that they do both to some extent protect unauthorized use. So if you infringe a patent, I can enforce that patent against you. And if I share my trade secret with you under an NDA and you breach that NDA, I can enforce that trade secret right against you. Also, patents and trade secrets are both intellectual property. They are property, just like physical property, they are intellectual property. You can license trade secrets and patents, you can sell them. They are a way that an investor values your company. They're also useful for other things like employee retention. So in California, for example, we have prohibitions against non-compete agreements. So you can't hire someone and tell them that if you work for me, after you work for me, you can't compete with me. That is pro se invalid in California. Other states are different. New York takes a different take on that. But in California, we don't allow non-compete agreements. However, if someone works for your company and you have patented an entire field in which that person might want to operate, your company might be the only place they can work if they want to stay in that technological field. So if they want to go get a job somewhere else, or if they want to go work for a competitor, fine, they're allowed to migrate their employment. But if you have mapped out your patents and trade secrets appropriately, they won't be able to work in that particular field without infringing your patents or at least your trade secrets, or their employers that hire them. These assets are particularly important in transactions, so for mergers and acquisitions, and you can litigate both. You can get injunctions, you can get money damages. Now, injunctions are much easier to get with trade secrets. Patent injunctions in the United States are very rare. Patent injunctions in Europe are far more common. But in the United States, if you do want injunctive relief, it's much easier to get that with a trade secret as opposed to a patent. Now, the problem with batteries. The problem with batteries is that there are just so many things going on with a battery. Many of you, if you're working on battery companies, you are innovating on different parts of the battery. You might be making new cathode materials. Some of you might be making new electrolytes. Some of you might be making just the same cathode that other people use, but with a different coating or a different size. Some of you might be working on modules or packs or pouches that contain all this stuff. Others of you are working on the software that runs batteries, and you don't even care what type of battery it is. Your software runs all sorts of batteries. So for batteries, there's just so many parts and components to think about, and you need a combined strategy to think about, how do you fit into this supply chain, and what about your contributions can be patentable, and what about your contributions can be protected as trade secrets, and are you taking the right steps to get those protective measures? And even if you did, would there be some back return on investment for you doing so? Part of figuring out the utility of these trade secrets and patents is thinking about how you might use them. And one way of thinking about how you might use these assets is threat assessment. So will someone copy you? Well, if that person is if you think someone might copy you, the second question is, will I even have a relationship with that person, or will they just independently copy me because they'll buy my product off Amazon and figure out a cheaper, faster way to build it? If someone's going to copy you and you don't have a relationship with them, then a patent is probably what you're going to need. Now, the question often becomes, what will they copy? Will they copy your entire device? Will they just copy parts of your device? And that which they copy, can you get a patent for that thing? So having a patent is great, but unless that patent actually covers, actually claims the thing that somebody else might copy, then that patent is not really going to be valuable to you. Now, trade secrets work when you have a relationship with someone. Now, you might have a confidential relationship with that person. So, are you worried about employee migration? Are you worried about rogue employees? Are you worried about contractors stealing information when they find out about your business? Are you partnering with other businesses and selling between businesses and thereby communicating your information? Are you seconding employees, meaning are you taking someone else's employees and having them work on site with you for a given amount of time? All these people hopefully would do so under a confidential relationship, under a non-disclosure agreement. And if that's the case, are you taking the steps to protect the information that has economic value that you're going to be sharing with them? Similarly, with licensing partners, if you're licensing a partner and you're going to be communicating information, do you have the right trade secret records in place so that you can prevent that licensing partner from misappropriating your information? Now, also, you got to be worrying about cyber threats. If your trade secrets are digitized, if your trade secrets are on a cloud or on some kind of server, potentially those are vulnerable to cyber threats. And if that's the case, then you want to make sure that you've taken the steps to protect those trade secrets. Okay, so what you've all been waiting for are the use cases, and we've got two steps here on use cases. And this is a situation where everyone's business is different and everyone's working on different things, and these are the questions that you want to be asking yourself as to whether a patent or a trade secret is going to be useful in your situation. So if you're making a material, or if you're innovating on a manufacturing process, or if you've come up with a new way of using materials that are known and maybe manufactured by somebody else, one question you want to ask yourself is what I'm doing potentially reverse engineerable by somebody else? If it is, then trade secrets are not going to be your venue for protecting your vehicle for protecting that type of information. Trade secrets don't protect against reverse engineering. For that, you need a patent. If what you're doing is not reverse engineerable, then yeah, you might want to be able to trade secret that information, depending on how discoverable it is, which we'll talk about in a second. Now, with materials, I often say that you might want both patents and trade secrets because whether or not something is reverse engineerable is often debatable. But once you have a physical thing out there, that is something that people can analyze and potentially can figure out what that physical thing is about. Manufacturing, when you manufacture a product, when you buy that product, it's often difficult to know how was that product made. Just because I buy a baseball doesn't mean I know, how they purchased their leather, how they tanned it, how they sewed it, what they put inside the ball, and how they put it inside. So manufacturing is one of the key places that I see clients keeping as trade secrets. So the chemical processes, the ways that they're making things, the way that they're using things internally that aren't publicly known or externally visible. Another question you want to ask yourself is convergent evolution. If I put a new product on the market, are people going to arrive at the same solution that I arrived at? If I put a new material out there, are people going to figure out that that's actually the best material? So if I put out a new high nickel NMC, is everyone going to say, oh, well, that's what I've always been waiting for was high nickel NMC. I want to copy that. If that's the case, well, then you need a patent for that. If that's not the case, if you think, well, I'm going to make high nickel NMC, but it's going to be really too expensive for anyone else to make because I own all the nickel in the world, well, that's okay. Maybe you keep that as a trade secret. Same thing with manufacturing. If you think that you figured out a chemical process, but everyone's going to figure out the same process at some point too, if they put enough researchers on that problem, then you might need a patent for that. If you don't think people are going to figure out your process because you thought, well, I got the best PhDs in the world, they figured out conditions that nobody else could have figured out, well, then maybe that manufacturing is best kept as a trade secret, because if you file a patent, that application for patent is going to publish before you even know that you got a granted patent, if you get a granted patent. And so just the process of filing that patent is going to tell the world what you're doing. So if you're in the manufacturing space, if you're in the process space, maybe keeping that as a trade secret. And the truth of the matter is that if you're a materials company, you're probably also a manufacturing company. You probably innovate on ways of making materials as much as you innovate on the materials themselves. So you might need a combined strategy for the products that you're selling that might be different than the processes that you've developed to make those materials. And the same thing goes with uses, right? If you figured out a new way to store a battery or discharge a battery or preheat a battery or do a predictive algorithm with a battery, again, you want to think about, will other people copy you? Will they not? Long ago, we saw treadmills that had little heart monitors where you could put your hands on a bar and it can measure your heart rate. That was something that, it came out with one company initially, and then every treadmill manufacturer started copying that. So that's a perfect example where you wanted a patent to protect that heart rate monitoring. Discovery. Unless you can find out that somebody is copying your asset, it may not be worth getting a patent. Patents are very expensive. There is a lot of life costs associated with that. And for example, with manufacturing, you might buy a competing battery from a competitor, but if you don't know how they made their battery, then having a patent on a process may not be that valuable to you, because you don't know that they're actually infringing it. So if you have a patent to a process, but you have no way to figure out if people are actually copying it, you might not have even the right to enforce it. So to file a patent lawsuit, you've got to have a good faith belief and evidence that somebody is copying you. And if you can't tell that somebody is actually copying your patent to make the product they're selling, then your patent isn't very useful. Independent invention, we talked about that earlier. If somebody can independently come up with the same idea that you have, trade secret is not the right vehicle to protect that. You need a patent. On the other hand, if you think you're smarter than everybody else and nobody's going to independently come up with the same idea that you did, well, then trade secret is probably going to be a better useful situation, because trade secrets are far cheaper. You can make those records yourself. You don't need to file a patent application with a patent office. But again, it doesn't protect against independent invention. A few more use cases before we turn to questions. If you are licensing your materials, you probably want a combined patent and trade secret strategy. So I don't know what your business is, whether you plan to independently operate and pass your business down to your children and just sell products on the market. If that's the case, you're not a licensor. So you probably can keep a lot of your information as trade secrets. On the other hand, if you developed a new type of battery, but you need to partner with a larger OEM or a larger manufacturer to scale up your product, then you're going to need to license that information to someone else who can take you over the finish line. And in that case, you probably need patents and trade secrets. You need patents because those are going to be useful for the licensor and yourself to exclude competitors. But you're also going to want trade secrets so that your royalties aren't cut off after the patent terms expire. You want to think about the confidential relationship you have with the people that you're working. If you have a confidential relationship with someone, trade secrets are a great way to protect that information. So if you're working with a particular manufacturer and you're going to tell that manufacturer, hey, I've got a new way to make this material. It's far more cheaper and faster than anybody else has known. Communicating that to them as a trade secret is actually preferable to a patent, because a patent gets published. And so even the people that you don't license to can read your patents and find out what you're doing. Same thing with joint development agreements. That's kind of like licensing. If you're working with someone, you probably want a multi-pronged patent trade secret strategy, because they're probably going to know a lot of the same things that you know. They're at least working on the same problem. That's a high chance they're going to independently invent on top of you. However, if you're working with someone and you're not doing a joint development agreement, you're just a supplier of someone else, you might not need a patent. If you're making a material and selling that material to other people, you might not need a patent, because you might be the only game in town. You might be the only person that can supply that material, in which case it may not be worth your time. Let me talk about artificial intelligence, because that is one of the big hot topics these days. Software and artificial intelligence is it has all of its own considerations. So generally the advice that we're giving clients these days is that the platform, the model that you've trained, the method by which you are training an AI model, that is best kept usually as a trade secret, because that is usually not discoverable by your customers. So typically your AI models might be running in a cloud. Somebody might be sending you data that you manipulate and then send them back an answer, but they don't see how that information is being manipulated in the cloud. And so all of those processes that are happening outside of the purview of the customer are probably best kept as trade secrets. On the other hand, a lot of the downstream uses and products of your AI models are potentially patentable. So if you're doing computational chemistry to figure out the best thickness of a lithium metal anode, or the best thickness of an electrolyte separator, or the best way to crystallize manganese oxide so that you don't have voltage fade, you definitely want to patent the output of your AI models. What is that crystal form of manganese oxide? That would be great to patent. But the model by which you are coming up with those answers is probably best kept as a trade secret. It really all comes down to the visibility of that AI model to your customers. Same thing with predictive algorithms. So if you have an algorithm that says, if this happens, shut off the battery, or if this happens, charge the battery, or if this happens, start warming the battery or cooling the battery, those actionable steps that you're taking based on some sort of output, that is ripe for patent territory. At the same time, you probably want to keep the model by which you make those decisions a trade secret, unless those become embedded on your, unless you're, if you're selling a car and someone can actually plug into their car and figure out, well, how is my battery figuring out when it should warm or not warm? Then you might need a patent. But to the extent that those predictive algorithms are outside the purview of the customer, you can keep those as trade secrets. So I did want to leave some time to do questions. I've got one more slide on just some of my takeaways, and maybe I'll just offer those up here. I've always been taught that you don't end on questions because you want to end on the notes that you intended to end on. But just remember, patents exclude everyone. Trade secrets exclude confidence and criminals. Both are monetizable. You can make money off both assets. Be strategic. Don't get a patent just because you think you need a patent, and don't rely on trade secrets thinking that that's going to be the best way to protect your rights if you actually do need a patent. Consider your technology, consider your business, consider how you're going to use these assets to make sure that the expenditure you take for acquiring them actually has the utility to give you value for doing so. So why don't we stop and take questions if there are any?
Awesome. This was very helpful, Todd. I really appreciate it. Let's see. Does anyone have any questions? Feel free to unmute yourselves, and maybe everybody should unmute themselves, or maybe turn on your videos. Let's have a more casual conversation.
I have a question.
Pankaj, did you have a question? Go ahead.
I have a question. So you mentioned that a company could have both conversion of both patent and trade secrets. And how does that timeline look like, and cost? For example, publication. Once the patent gets public, what becomes public, then trade secrets, kind of the processes of the manufacturing comes in, kind of for a typical startup. What does the roadmap look like? I guess that's my question. I don't know if that question.
Yeah, I mean, patents always publish on a very predictable timeline. They publish exactly 18 months after you file them. If you file a provisional and then a non-provisional, that's always 18 months after your provisional. If you just file a non-provisional, it's always 18 months after your earliest filing date. So patents publish on a very predictable timeline. I think, with IP, you want to think about having sort of a process in place, preferably automated, where you are generating IP over time, right? It's so often that you file a patent application, it won't be examined for 2 to 3 years after you file it unless you accelerate. And during that timeline, it's very often that you make new innovations, and sometimes those new innovations didn't get captured in your original filing. And so having a serial patent filing strategy, I think, is really important. At the same time, having a serial trade secret collection policy is also really important. For startups, I say you've got to incentivize the people that work for you to make those disclosures. So there should be some incentive, whether it's monetary or part of their job description or some way that you encourage people to give you disclosures. And those disclosures go to some committee that can take action on those disclosures. So at a minimum, new invention disclosures should be protected as trade secrets. You can always convert a trade secret to a patent. You can't do the reverse. You can't convert a patent to a trade secret. But I think building up your trade secret records is one of those things that you should be doing all the time. So every 3 or 4 months, you should be having a meeting and saying, what new trade secrets have we developed? Have we made records? Are we securely storing them? And at the same time, every 3 or 4 months, evaluating, can we convert any of these trade secrets to patents? And if we did, would there be a business case for doing so? But having some sort of regular routine audit of your company that you continually develop these materials, because patents expire, the best kept secrets sometimes leak out. And so you want to be generating new ones at the same time that you're protecting old ones. It's a continuous process.
I have a question. I probably know the answer, but I'm a little confused about it. So if, let's say there is a specific type of anode, let's say silicon anode, right? 2 different companies come up with the same silicon anode, but with very different manufacturing processes that basically impacts the price, the cost of that anode material. But it's still, because the end material is the same, I would assume that they're violating somebody else's patent. Is that right?
It's a great question. And the answer really depends on what did you patent, because you can patent the silicon anode separate from a patent on the method of making it, right? So if someone has a patent on the silicon anode, even if you manufacture it by a different method, if you arrive at my same silicon anode, you infringe my silicon anode patent. On the other hand, if I have a patent to a manufacturing process and I make a product that you also make, if you use a different process, then you're not infringing my process patent. So it depends on what patent you have. Did you patent the method of making it? Did you patent the material itself? So that's one of the first key considerations. And, on the side of method of making it, I think you also want to think about, are you going to be in the business of manufacturing, or are you going to partner with someone that you're going to manufacture with? If you're going to partner with someone that you're going to manufacture with, you got to think about, how am I going to communicate that to them? Am I just going to license my patent and they're going to make my patented material for the term of my patent? Or potentially better, do I have a trade secret to that process and I license my trade secret to that manufacturer, and then they can make that on behalf of me? So it very much depends on what you're patenting, and I think that's why when people say they have a patent, I often say, well, congratulations, but what is it that you've patented, right? The specifics really matter.
Interesting. Okay.
Todd, this is Dan. I have a quick question.
Yes, please.
I guess listening to you talk about licensing trade secrets, is that something that your firm can help companies with? Because, little guy has to be careful how close they stand to the big guy.
Sure, absolutely. Yeah, I mean, we help people license trade secrets all the time. And in fact, trade secret licensing it's very similar to patent licensing, but it's actually in some ways preferable, because trade secrets are broader, right? Trade secrets protect more than just a patent. They protect some stuff that's not even patentable, right? So like if you rediscover a process that people knew about in the 70s, but they've since forgotten about, you could license that process to somebody else. That could be a trade secret.
Private agreement.
What?
The private agreement.
Yeah, absolutely. A confidential agreement. And trade secrets you can also parse out into much smaller pieces. So for example, if you've got a manufacturing line, you don't have to think about the entire line as a trade secret. Maybe the line has 10 trade secrets associated with it. And if somebody wants to license your work, they need to license all 10 parts of that line. Now, a patent might have a lot of inventions involved in it. So you can license claim by claim or parts of the patent, but typically, most commonly, people just license the entire patent. And when you do that, you're giving someone a lot of things at once. And so to get the right valuation is to say, look, I'm going to license you 10 trade secrets and a patent, and that's probably going to be more expensive than if I just license a patent, because there's more things that you're getting. So I think with trade secrets, you really are in the driving seat as to how you particularize this commodity and how you divide it up, and then how you divide it up determines how you sell it. And with licensing, remember, trade secrets can be protected indefinitely, right? So that means your royalties can go on indefinitely, right? Coca-Cola can make royalties off their recipe for hundreds of years, whereas a patent, once that patent expires, by law, you cannot collect a royalty on that patent anymore. So once the patent term ends, the license ends. So you want to be sophisticated in the sense of licensing not just a patent. There's got to be something else in there, because 20 years goes by quicker than you would think, and before you know it, that patent is expired. And now what is it that you're licensing? Now you can license your brand, you can license your trade secrets. There's other things that you can license. But if you put all your eggs in one basket thinking I'm going to license a patent, just know that there's an end date to that.
Can you also talk about iterations of like patents, and then also like maybe, because I know that that's kind of expensive to do iterations of patent to prolong, expand the lifetime of a patent. How would that play? Like, how would the trade secrets come into play, like to help with that process, I guess?
Yeah, I mean, trade secrets. So I think Irene, what she's talking about is that you file a patent application, and usually before it publishes at that 18 months, we like to file any slight iterations on that same topic so that you don't create prior art against yourself. If you file a subsequent patent before your first one publishes, then your first one is not prior art. And same thing with trade secrets. When I work with clients and we develop trade secret records, every couple months, 3 months, 6 months, whatever tempo works out for that client, you want to revisit your trade secret record. So if you had a process and you knew that this pressure, this temperature, this time of reaction worked really well, you want to periodically revisit that. So every 6 months, maybe you go back to the scientist and ask her, hey, last time I talked to you, you said 100 degrees Celsius and 1 megapascal and 10 resident time in the oven. That was what was great, right? Is that still the case? And maybe she'll say, yeah, those process conditions still work, but also now I like to have this cooling step between these two parts, because if I cool it, then everything works out a lot better. Well, you just augmented your trade secret record, right? You had a record before that was temperature, pressure, and residence time, but now she said, but there's now this new thing I worked on, which is this cooling step. So you want to augment your trade secret records over time. And that's something you can do internally, right? There's no publication. It's your own record keeping. But you certainly want to keep a tab on that and have some kind of routine reminders to audit your portfolio.
May I ask like a small question?
Of course. I don't know who's asking, but yeah, please.
Okay. As I mentioned, both trade secret and the patent are available for even the same technology, and the two measures overlap each other to a certain degree. So my question is, assuming a piece of technology was under protection of trade secret, and it has been successful up to date, but something has changed. For example, its competitors are going to likely make substantial progress in the near future. So in this circumstance, can we switch from trade secret to patent to protect the same technology?
Yeah, that's a great question. So thank you for that. Yeah, if you have a trade secret that you're keeping as a trade secret, and all of a sudden you get wind that maybe your competitors are now doing that, what you thought was a trade secret, you can convert a trade secret to a patent as long as your trade secret hasn't been published and you haven't commercially exploited that trade secret. So if you have confidentially sold that trade secret, even if you didn't publish that trade secret, at least in the US, we have something called the on sale bar that will prevent you from filing a patent application on that trade secret. So you can convert a trade secret to a patent as long as it's not publicly available or commercially exploited. You can't do the reverse. You can't make a patent become a trade secret. but you can have a trade secret become a patent if you get ahead of those statutory bars. So you do want to monitor the market. You do want to make sure that if you exploit a trade secret, just know that once you sell your trade secret, you are foreclosing your ability to patent that same trade secret. So you got to be strategic in that. But great question.
Okay, thank you.
I had a quick question.
Please.
So, like Sama said, we're an early stage company. We also work on the silicon anodes. And the problem we've been tackling is that ultimately the final structure of the material is similar to probably other companies. It's just the process that is different. And we're early stage, so we also have our huge Goliath competitors. And I guess we're struggling with figuring out this reverse engineering issue is when we are supplying our materials to our first customers. They might be able to reverse engineer what the porosity is or the particle sizes. So in the battery field specifically, do you know of any cases or any ways early stage companies can navigate this, getting their materials out and having them reverse engineer?
Yeah. So the key thing with those is having good contracts. You can have non-reverse engineering clauses to your contracts. When you supply someone a material, in your material transfer agreement, you can say, look, you agree not to reverse engineer this material. You agree not to take the crystallography of this cathode material. You agree not to do any chemical ICP analysis to find out what's inside here. So you can control the use of that material when you give it to somebody else. So not only can you say you've got to maintain it in confidence, like a non-disclosure agreement, but you can also add to that contract, you can't do certain things with this material, right? You can't give it to somebody else. You can't reverse engineer it yourself. And so that is how you maintain those trade secrets. So yeah, you've got to get your business done. You've got to get it in customers' hands. You've got to get them to evaluate it. And at the same time, you tell them, for the benefit of trying my material, you have to agree to these provisions that don't destroy my trade secrets.
That's a good point. Thanks.
Awesome. Is there any other questions? No? Great. Thank you so much, Todd. Thank you everyone for joining. The recording is going to be available. I'm gonna share it. I'm gonna send an email to everyone. Feel free to share it with your friends. It's also going to be on our YouTube channel. We're going to have a meetup, in-person meetup at 9:00. It's going to be a monthly event. It's going to be more laid back, casual. Everybody speaks, everybody talks. We will have a round of introduction. It's going to be August 19 at 5 o'clock at 9:00 in San Francisco. Please join us. And yeah, Todd, we should have these more often, actually.
Yeah. I've already bought my ticket to August 19th, so I'll see you guys there.
And then also, Todd, is that okay to share this on YouTube?
For sure. Yeah.
Okay. Fascinating. Awesome. Well, have a wonderful day, everyone. Today is Wednesday, right? Oh, it was hump day. So we have passed like more than half of the week. Yay. All right. Take care.
Thanks, everybody.
Thank you.
Thank you.
Thank you.